Let's talk about ACA Code of Ethics, Section A. Each section of the Code of Ethics starts with an introduction. Then it addresses standards within the section, and even sometimes has a little introduction before the standards. So Section A is all about how counselors facilitate the growth and development of clients in a way that fosters the interest in the welfare of the client and promotes the formation of healthy relationships. Trust is the very cornerstone of the counseling relationship, and we have a responsibility as counselors to safeguard and protect our clients' privacy and their confidentiality. So we actively attempt to understand our clients' diverse cultural backgrounds and to explore our own cultural identities and how our cultural identities may affect our values and our beliefs about the counseling process. Also, counselors are encouraged to contribute to society by doing some of their professional activities for little or no financial return, which we call pro bono. So Section A1 is regarding client welfare. And Standard A1A talks about our primary responsibility as counselors is to respect the dignity and promote the welfare of our clients. A1B addresses our records and documentation. As counselors, we are going to create, safeguard, and maintain documentation that is necessary for rendering professional services. This is an important distinction because the documentation that's necessary to render professional services can vary depending on the setting that you're in. So school documentation for a school counselor may look very different from documentation for a clinical mental health counselor or a career counselor. Regardless of the medium that we use, if we're writing our notes, if we're keeping them on a computer, we include sufficient and timely documentation to facilitate the delivery and continuity of our services. So it's important for us as counselors to take steps to make sure that our documentation accurately reflects client progress and any services we've provided. And if we amend our records, we make sure that we take the steps to note whatever amendments we've made according to our agency or institutional policy. Of course, we work together with our clients to devise a counseling plan that will offer reasonable promise of success and is consistent with the abilities, the temperament, the developmental level, and the circumstances of our clients. Counselors and clients are going to review and revise these counseling plans to assess their continued viability and effectiveness while respecting our clients' freedom of choice. That goes back to that principle of autonomy. We want to involve our clients' support network to the extent possible because we recognize that support networks hold meanings in the lives of our clients. So we might engage the religious, spiritual, or community leaders of our clients, or family members or friends as a positive resource, but only when it's appropriate and only with our clients' consent. Informed consent is a key component of the counseling process. Standard A2A defines what informed consent is. So our clients, again, going back to autonomy, have the freedom to choose whether to enter into or remain in a counseling relationship. And they need adequate information about the counseling process and about the counselor that they're seeing. So as counselors, we have an obligation to review in writing as well as verbally with our clients the rights and responsibilities both of us as the counselor and them as the clients. Informed consent is ongoing. We do it at the beginning, but we do it also throughout the counseling process. And we appropriately document the discussions around informed consent as we have them throughout the counseling process. So standard A2B talks about the types of information that we need to provide our clients in the informed consent process. So we're going to first of all explain to our clients the nature of all services that we provide. We're going to inform our clients about issues such as the purpose of counseling, the goals of counseling, the techniques that we use, any procedures, whether it's office procedures or counseling procedures, the limitations of counseling and potential risks involved, as well as the benefits of service. We talk about our qualifications and our credentials, our experience, particularly relevant to our clients that we see, and our approach to counseling. So think, for example, our theoretical orientation, continuation of services in the event of our death, or if we get stricken with an illness or in an accident that prevents us from seeing clients. What is our contingency plan? How do we continue to take care of our clients in that situation? What role does technology play in our practice? And any other pertinent information. We take steps to make sure that our clients understand implications of diagnosis and the intended use of any tests or reports that we use. Additionally, counselors inform clients about fees and billing arrangements and any procedures, including non-payment of fees. You might realize that if you have a client who's not paying and you go after them aggressively with a collection agency or some other service, that can really damage the counseling relationship. So you've got to consider these things. You do run a business if you're in private practice, and you deserve to be paid. So you've got to figure out how to address those situations. And the clients need to know in advance what your policies are. Clients have the right to confidentiality and to be provided with an explanation of its limits. So that way they can make an informed choice about what to tell you and know in advance if what they tell you is going to lead to your need to report it. We need to let them know if we're under supervision, or if we are meeting regularly with some type of treatment team or interdisciplinary team where information will be shared. We also need to inform our clients about how to get clear information on their records, how to participate in their ongoing counseling plans, and the fact that they can refuse services or modality changes. And when they make those choices, we will advise them of the consequences of such a refusal. We have to communicate information to our clients in a way that is both developmentally and culturally appropriate. So developmentally, if you're working with someone maybe who is intellectually handicapped or disabled, or maybe even a minor. Now, of course, minors can't provide consent. That is up to their parent or legal guardian, but they can provide assent, which we will talk about momentarily. But we have to use clear and understandable language when we discuss these issues related to informed consent. We have to make sure we're expressing it to our clients in a way that they can understand it, both developmentally and culturally. And when clients have difficulty understanding the language that we use, we may have to provide necessary services, such as arranging for a qualified interpreter or translator to make sure that our clients are very clear. Sometimes we might need to have our informed consent written in other languages. In collaboration with clients, we're going to consider the cultural implications of informed consent procedures, and where possible, adjust our practices accordingly. So not everybody has the ability to give consent, particularly minors and certain incapacitated adults. For example, maybe an elderly client who's dealing with some dementia. So it's important to, when someone is unable to give consent, that we seek their assent. That means that they are agreeing, they are giving their agreement to the services. We include them in the decision-making as appropriate. And we recognize the need to balance the ethical right of our clients to make choices, their capacity to give consent or assent to receive services, and then parental or familial legal rights and responsibilities to protect these clients and make decisions on their behalf. So for an elderly client with dementia, they may have someone who has power of attorney, who has to make those decisions on their behalf. For a minor child, it is usually a parent or legal guardian. Standard A2E talks about mandated clients. Clients may come to you and be mandated, whether it's through a court system, where you'll have to report back to a judge or a probation officer maybe. Also, clients may be mandated through their work if they've come to you through an employee assistance program. So we have to talk in advance with our clients. Again, this is part of the informed consent process. Talking about the limitations to confidentiality for these mandated clients. We also are going to explain in advance what type of information we have to share and with whom we may be sharing it before we begin the counseling services. And a client can choose to refuse the services. And in that case, we have to do to the best of our ability, we have to discuss the consequences of refusing counseling services. For these mandated clients, if it's the court system that is mandating them to our service, then it could be jail time or a fine that they are given if they choose to refuse counseling. For an employee assistance program, it could be loss of a job. Standard A3 talks about clients who are being served by others. We may work with clients who are in counseling with another counselor. Perhaps they're working on substance abuse issues, but the substance abuse counselor refers them to another counselor to work on another diagnosis that they have, perhaps anxiety or bipolar disorder or something like that, clinical depression. So in that case, the client may have two counselors, or maybe the client is working with a psychiatrist for medication management or a psychologist and undergoing some testing. When we learn that our clients are in a professional relationship with another mental health professional, we need to request release from the client to inform and collaborate with other professionals. Section A4 is about avoiding harm and imposing values on our clients. So we act to avoid harm, of course, whether that is to our clients, a trainee, if we're supervising someone maybe for licensure, and any research participants that we may be working with. And we minimize or remedy unavoidable or unanticipated harm. And I just want to go back for a minute and point out that we don't always, harm doesn't always come intentionally, but it doesn't detract from the fact, even if it's unintentional, that it is harm. So it's important for us as counselors to recognize, even if we didn't mean it, that we have to fix it. So just to give an example, maybe you're working with a client who is from a different racial or ethnic background or a different religion, and you say something and it's a microaggression, and you don't even realize that what you're saying is harmful to the client. When you recognize that you've done harm, maybe the client brings it to your attention, or in reflecting on your practice later, you come to realize that what you said potentially did harm. That's when we need to then remedy the harm that we've created or done. We have to be aware of our personal values. It is so important to know what our values are so that we can then avoid imposing our values, our attitudes, our beliefs, and our behaviors on our clients. It's important to respect the diversity of all of our clients, our trainees, our research participants. And when we realize that we're at risk of imposing our values onto our clients, we seek training for that area where we are struggling, especially if our values are inconsistent with our clients' goals, or they may become discriminatory in nature. To give you an example of this, if you have a client who comes to you because they're struggling with some relationships at work, and it's impacting their ability to do their job. And in the process of the counseling, the client comes out to you about their sexual orientation and shares with you that they are gay. And maybe this goes against your values. Maybe you've been raised in a religion, or you've been raised in a spiritual belief that is a sin, that is wrong. But you are there to help the client regardless. You cannot allow those values to impact your ability to help your client. And if that is something that you struggle with, it becomes important at that point to then seek supervision and get training. Section A5 talks about prohibited non-counseling roles in relationships. So the very first one we've already talked about: sexual and or romantic counselor-client interactions or relationships, whether that is with a current client, with a client's romantic partner, or with a client's family member. It is prohibited. It is off limit. It is not okay under any circumstance. This is one of those ethical standards. There is no shades of gray. This one is black and white. So this prohibition applies to both in-person and electronic interactions and or relationships. We also don't engage in counseling relationships with people that we've had a relationship with, a sexual or romantic relationship in the past. We have an inability in those situations to remain objective. So if we had a past fling that seeks us out for counseling because they think we'd be a great help to them, it is our duty at that point to refer them out. So sexual and or romantic counselor-client interactions or relationships with former clients, with their romantic partners, or their family members are prohibited for a period of 5 years following the last professional contact. So you're at a Christmas party and you run into a client that you haven't worked with in years, and you're pretty sure it's been 5 years, but when you go back and look at the records, it was 4.5 years ago. It is off limits. 5 years is the time. So this prohibition applies to both in-person and electronic interactions or relationships. Before engaging in sexual and or romantic interactions or relationships with former clients, with their romantic partners or their family members, you need to really think through before you engage in that relationship. And you need to write it down, whether that interaction or relationship could be viewed as exploitative in any way, or whether there is still a potential to harm this former client. In cases of potential exploitation and or harm, you're going to, of course, avoid entering into such an interaction or a relationship. Of course, my advice is just don't do it, right? Like avoid it altogether, even if it's been 5 years. There naturally has been cases where a client and a counselor has married their former client. Maybe they've waited that 5 years time period. And then maybe after a time, they go through a bitter divorce. And then the spouse comes after the counselor, the ex-spouse comes after the counselor, claiming that they were exploited, that they were manipulated, or that power differential, the counselor used it against them. So that's why it's really important to document in writing before you engage in any kind of relationship like that. Of course, counselors are prohibited from engaging in a counseling relationship with friends or family members with whom they have an inability to remain objective. And that last part is really crucial, because if it's a distant relative that you have no relationship with, or you're not close to, and you really don't know them, and they're not someone that your close family members are close with, then you can probably remain objective and be a good counselor for that person. So it's not just the fact that they are a family member, but it's the fact that you're close enough that you can't remain objective. You're also prohibited from engaging in personal virtual relationships with individuals that you're in a current counseling relationship with. So in other words, you should not be friends with your clients through social and other media. Now, it is okay to have a professional social media site, but it would be one where you would not interact with, post back and forth with clients. That would be inappropriate. And certainly you shouldn't be looking at their social media. That's a violation of privacy. So make sure that you have blocked any access for your clients to see your social media accounts. Unless it's a professional account, of course. Section A6 talks about managing and maintaining professional relationships. A6A talks about previous relationships. So you need to really think through all the risks and benefits of accepting as clients anyone with whom you've had any type of previous relationship. So this isn't talking necessarily about romantic or sexual relationships. Now we're talking about any previous relationship. So these potential clients could be individuals that you've had a very casual, distant, or past relationship with. Maybe you and the client have been members of the same professional association, organization, or community. Maybe you attend the same church. If you accept these clients, it's important to take appropriate professional precautions, such as informed consent, consultation with another professional, supervision with a supervisor, and engage in some documentation to make sure that your judgment is not impaired and no exploitation occurs. A6B talks about extending counseling boundaries. So what this means is relationships that are outside the normal parameters of counseling. So you're going to first consider any risks and benefits of extending current counseling relationships beyond conventional parameters. Examples include attending a client's formal ceremony, like a wedding or commitment ceremony, a graduation, purchasing a service or a product by a client, unless you're in a bartering relationship, which we'll get to in a minute. Maybe visiting a client's ill family member in the hospital. When you extend these boundaries, it's really important, again, to make sure that you have gone through an informed consent process, that you've sought consultation with another professional and or supervision with a supervisor, and you've documented this boundary extension to make sure that your judgment is not impaired and that no harm occurs. If you extend boundaries as described in section A6 and A6A, A, and A6B, officially document before the interaction, if that's possible, the rationale for such an interaction, the potential benefit for the client, any anticipated consequences for the client or the former client, and other individuals involved with the client or former client. When unintentional harm occurs to the client or to the former client or to an individual involved with the client, the counselor must show evidence of trying to remedy any harm. So if a counselor extends their boundaries, if I'm repeating this, I apologize. They have to document prior to the interaction the rationale why, the benefit, the consequences for the client or former client, and anyone else significantly involved. So if unintentional harm were to occur, then it's up to the counselor to try and fix the situation and remedy it. A6D talks about role changes. So sometimes our role may change with the clients that we serve. For example, maybe we're working with a family and then we change our role and work with one individual from that family, or vice versa. We're working with an individual and then we bring the family in. That's just one example. So if we change a role from our original or most recent contracted relationship, we've got to get informed consent from the client and explain their right to refuse any services related to that change. So again, changing from individual to family counseling or from family counseling to individual counseling, changing from an evaluative role to a therapeutic role. So an example of this might be if you're a custody evaluator and you're working with a family, or working with the court system to evaluate a custody situation, and then you go into a therapeutic role, you would need to do informed consent. And then of course, if you're a mediator and you go into counsel role or vice versa, clients have to be fully informed of any possible consequences, whether it's legal, financial, personal, or therapeutic, that could occur as the result of a counselor role change. A6E talks about non-professional interactions or relationships that are not sexual or romantic in nature. So we try to avoid entering into even a non-professional relationship with a former client, their romantic partner, or their family member, when it could be potentially harmful to the client. So this applies to both in-person and electronic interactions or relationships. Section A7 gets into roles and relationships at the individual, group, institutional, and societal level. So A7A talks about advocacy. So when it's appropriate, counselors advocate at an individual level, at a group level, at an institutional level. Again, that happens a lot in schools, right? And at societal levels. For instance, in the case of maybe a law that's about to be passed at the state and you go to the Capitol and advocate against it. So that's to address potential barriers and obstacles that would inhibit access and or growth and development of clients. A7B talks about confidentiality along with advocacy. I mean, clearly, we're not going to go into our client's place of business to advocate for them and do that without their consent, right? We've got to have our clients' consent before we engage in advocacy efforts on their behalf, especially to work towards removal of systemic barriers or obstacles that inhibit client access, growth, and development. At this point, y'all, I'm going to just leave the video off because it keeps shutting off automatically. So hopefully the sound is recording. When a counselor agrees to provide counseling services to 2 or more people who have a relationship, so think couples counseling or family counseling, it's important to clarify at the outset which person or persons are the clients and the nature of the relationship if the counselor will have that the counselor will have with each person involved. So a lot of marriage, couple, and family counselors consider the family as one unit, their client, although you can't bill insurance for a family. But if it does become apparent that the counselor may be called upon to perform a conflicting role, it's important to clarify, adjust, or withdraw from roles appropriately. With group work, it's really important that we screen any prospective group members. When you put people together in a group, it's important to make sure that their goals and their needs are compatible with the goals of the group, and that one person is not going to impede the group process, and the well-being will not be jeopardized by the group experience. In that group setting, we have to take reasonable precautions to protect our clients, right? So you're dealing with a group of people. You want to make sure each and every individual in the group is protected from physical, emotional, or psychological trauma. So it's sometimes we have to intervene if one group member is bullying another group member or harassing, or even just maybe saying something racist, for example. We have to intervene and protect our clients. That's a no-brainer. Section 810 is going to talk about fees and services. So if you're working in an organization like a school or an agency or an institution that provides counseling services, and you have a private practice or see clients independently somewhere else, you are not going to refer clients to yourself unless there are policies in place from your organization that allow that. So for example, in the school setting, quite a few of the school counselors in my school district that I worked in did see clients in private practice. However, it would have been unethical for them to refer students to their private practice. But if your organization has a policy in place that allows for that, then of course you have to also let your clients know of other options that they could seek in addition to your counseling services. But I just recommend staying away from that. It's important that you do not participate in fee splitting. So in fee splitting, that is sort of like an agreement between you and another service provider where you share certain fees, and you don't give or receive commissions or rebates or any other form of remuneration when you're referring clients for professional services. We just have to be really careful. I think, like as a counselor, if you have a couple that you're working with and they're having financial difficulties, you might refer them to a financial advisor. And if you refer them, again, you probably want to provide them with several options, but it's important that you're not benefiting from that referral in any way. When you're establishing fees for your counseling services, consider the financial status of your clients and the place that you're located. I mean, counseling is going to be very different in California than it's going to be in Hammond. California has a really high cost of living. So that's where the locality comes into play. But also you're consider any hardships that your clients might be facing. Make sure that they have access to mental health care. So if your fees create a hardship for your client, then you either adjust your fees, or if it's permissible legally, you can help your client find a comparable and more affordable service. When your clients don't pay, if you do intend to use a collection agency or use some type of legal measures to collect fees from clients who don't pay, then you have to put that in your informed consent. They need to know that up front at the start, before the first counseling session, and then they need to be reminded of it so that they have the opportunity to make payment in a timely fashion before you take legal action. You may barter. In the olden days, before this iteration of the ethical standards, there was a time when bartering was off limits and not allowed. Counselors may barter, but only if bartering does not result in exploitation or harm. If the client requests it, you're not going to bring it up. But if the client requests it, and if such arrangements are an accepted practice among professionals in the community, so it's standard practice among other professionals. It's not something unique and something only that you do. So for example, maybe your client is, as they say, a starving artist. They're an artist, but they're not making a lot of money. And they say, you know what, if I can paint you a picture for your office or for your home for payment of counseling. You're going to consider, of course, the cultural implications of bartering, because it is accepted in some cultures, and discuss relevant concerns with clients and make sure you document. Again, documentation is so important. Document agreements and a clear written contract. Also, in previous iterations of the ethical standards, it was not appropriate to take a gift from a client. However, I think we've come to realize that that can be seen as disrespectful in some cultures. So as we've become more culturally aware and culturally competent, then gift receiving has become a little bit more acceptable. So it is important to understand the challenges of accepting gifts from clients and recognize that in some cultures, a small gift is a token of respect and gratitude. So it's important to determine when to accept a gift from a client and when not to. And you need to take into account the therapeutic relationship, the monetary value of the gift, the client's motivation for giving the gift, and your motivation for wanting to accept or decline the gift. Let's say, for example, you have a client who presents you with a piece of jewelry. For one client, a piece of jewelry that might be much more valuable to them, because if they're low income or don't have a lot of monetary means, then giving you a piece of jewelry might be like a really expensive gift, versus a high net worth client who's got tons of money. Then that piece of jewelry might just be a little token. So the same gift, depending on the client, can have different value, different meaning. Termination and referral. If a counselor lacks the competence to be of professional assistance to a client, then they're going to they avoid entering into or continuing the counseling relationship. So I think it's important to acknowledge that, if you see that your client is not making improvement, then it's time to terminate. If they've met their goals, it's time to terminate for sure. But sometimes clients will keep coming back week after week after week, but they're not making any progress. Then it might be time to terminate and refer. But be knowledgeable about culturally and clinically appropriate referral sources if you're making a referral, and suggest those alternatives. But it's really important, of course, that you not terminate a client or refuse to accept a client because of your values. So that's important to consider. If clients decline your suggested referral, you can discontinue the relationship. So you refrain, here it is, A11B, right? You refrain from referring a prospective or current client based solely on your personally held values, attitudes, beliefs, and behaviors. You need to respect the diversity of clients and seek training in those areas where you're at risk of imposing your values onto the clients, especially when the counselor's values are inconsistent with the client's goals or are discriminatory in nature. You terminate the counseling relationship when it's apparent that the client is no longer needing your assistance. They've met their goals, or they're not benefiting, or maybe they're being harmed by continued counseling. You may terminate your counseling when in jeopardy of harm by the client or by another person with whom the client has a relationship. Like, you don't need to put yourself in harm. That would be appropriate to terminate. When a client does not pay agreed upon fees, you can terminate. And counselors provide pre-termination counseling and recommend other service providers when necessary. For the appropriate transfer of services, when counselors transfer or refer their clients to other practitioners, ensure that appropriate clinical and administrative processes are completed and open communication is maintained with both clients and practitioners. Counselors do not abandon or neglect clients in counseling. I witnessed this one time. I had referred a student to outside counseling. I'd given them a list, but they picked one of the people off the list, and that counselor just kept repeatedly canceling and trying to reschedule. And that's considered abandonment. We do not abandon or neglect clients who need counseling. Counselors assist in making appropriate arrangements for the continuation of treatments when necessary, especially if you're going on vacation or you have a serious illness. You're going to help make sure that they have continuity of care. And that concludes Section A of the ACA Code of Ethics.